everybody, this is Aishley Verma, an intern with LEXIS and Company, and today in this video I will be dealing with a case named State Government of NCT of Delhi versus Ramtej. Citation of the case is Criminal Revision Petition 464 of 2017. It was appealed in the Supreme Court of India, and the bench consists of Justice Honorable Justice Vinod Goyal, and date of the judgment is 17th October 2017. Head notes of the case include section 302, 376A, 300 of IPC and section 212, 217 and 464 of the CPC. Facts of the case. If we talk about the facts of the case, so the facts of the case are following. The prosecution charge sheeted the accused respondent under section 302, 201, 376A, 377, 392, read with section 411 of IPC. The ASJ, which can be seen in order dated on 9th September 2015, framed charges under section 201, 376A, 392, 411 of IPC, stating that there was no material for framing charges against the accused under section 377 of IPC, and that the offence under section 376A was a graver offence than the offence under section 302 of IPC. The cause of death of the deceased was due to the combined effect of strangulation and shock due to visceral injuries and the blood loss due to insertion of wooden object in both the private parts of the as per the postmortem report, and therefore there was no question of framing an alternate charge under section 302 of IPC. The order dated on 9th September 2015, the ASJ was assailed by the state in criminal revision petition of number 254 of 2016. It was argued by the state that the charges under section 302 of IPC has not been framed by ASJ, even though there was an ample medical evidence on record. This petition was disposed on 23rd August 2016, with liberty to the state to approach the ASJ for framing a charge based on the material before the court. The petitioner exercised the liberty so granted by this court and moved an application before the ASJ for framing an additional or alternative charge under section 302 of IPC. This application was dismissed, which can be seen in a pugnant order dated on 29th August 2016, whereby the ASJ surprisingly concluded that this application was filed beyond the scope of liberty granted by the court, wherein the state had prayed for amendment of the charges and particularly for framing of charges under section 302 of IPC. The ASJ also observed that the application was devoid of any merit in view of his earlier order dated on 9th September 2015. The criminal revision petition impugns an order dated on 29th August 2016 passed by the Court of Additional Session Judge, Fast Track Court, Patiala House Court in New Delhi. So this was a fact. If we talk about the issues, so there were three issues involved in this case. First is issue whether the trial or the revisionist court has the power to alter or add charges to the original charges. Second issue is whether the offence under section 302 of IPC is the same as genus and species as the offence gives under section 376A of IPC. And the third charge is whether there is a sufficient material on record to frame a charge under section 302 of IPC in the present case. So the judgment, the judgment of the case is following. The court finally directed that the repugnant order dated on 29th August 2016 passed by ASJ declining the request of the prosecution to frame additional charge under section 302 of IPC is set aside. Also, the ASJ was directed to frame an additional charge under section 302 of IPC and commence the trial in accordance with the law, keeping in view the provisions of section 217 and section 464 clause 2A and B of the code. It is directed that the trial shall be continued on day-to-day basis. And the ASJ shall conclude the trial within 3 months on the receiving of this order. The trial court record be sent back forthwith. A copy of this order be circulated to all the judicial officers for the knowledge and guidance. So this was it held in the case. Hope you like the video. Thank you so much.